Hey, the business guy, I have a question for you. If I own a property with somebody else, can I sell my half?
When you buy a property with someone else, can you just sell your half? Well, sometimes and sometimes not. You'll know pretty soon. Welcome back to The Business Guy, and today we're diving into the intricate world of real estate ownership. And whether you're a first-time buyer, a seasoned investor, or simply curious about how property ownership works, you're in the right place. We're tackling a topic that often confuses many, the difference between undivided and divided interest in real estate. So let's break it down and make it as simple as possible and why it's important for you to know. Imagine you and your spouse or you and your friend decide to buy a property together. This scenario can play out in two main ways, through an undivided interest or a divided interest. So what do these terms mean? And how do they affect your rights and responsibilities as an owner? Let's go ahead and start with an undivided interest. An undivided co-ownership means you and the other owners collectively own the entire property. So nobody owns a specific part. Instead, everyone has equal rights to the whole property. This setup can be seen in what's called joint tenancy. Now, a joint tenancy requires what we call the four unities, which we'll define in a moment. Unity of interest, unity of time, unity of title, and unity of possession. This means all owners must have equal share, must acquire their interest at the same time through the same document, and have equal rights to enjoy the property. The unity of interest refers to the share of each owner, which must be equal. In being equal, the interest must be the same type and must run for the same duration. If one owner has a larger or smaller share on the property, the unity of interest is broken. Unity of time relates to when the owners acquire their interest. The owners must acquire their interest at the same time, or there's no unity of time. Unity of title means the interest held by each owner must originate from the same instrument, i.e. the title. If the share of either owner stems from a different instrument, there is no unity of title. The unity of possession refers to each owner's right to possess the whole property. Any agreement where the share of the property does not allow an owner the right to possess a portion of the whole property breaks the unity of possession. So all four of those are required at the same time to own a property by joint tenancy. And when you own a property by joint tenancy, unless you go to court and do some legal jujitsu, you need both parties to sign in order to sell or refinance the property. So joint tenancy is like joined at the hip when it comes to owning the property. Now, the beauty of joint tenancy is the right of survivorship. If one owner passes away, their share automatically goes to the surviving owner. But if any of the four unities is broken, say one owner decides to sell their share, they can get a court order, for example, and the joint tenancy morphs into tenancy in common, changing the game rules. Now, another form of joint ownership or undivided interest is called tenancy by the entirety, where married couples, and it's only married couples, may jointly own real property by tenancy by the entirities. Now, this creates a third person, the marital unit, and what this means is that neither spouse owns the property individually. Instead, they each have an undivided 100% interest in the entire property. Now, in a divorce or other dispute, one party can file what is called a partition action to force the sale of jointly owned property. Under Florida law, for example, a co-owner of a real property may file a lawsuit against the other co-owner when they cannot agree on how to continue their joint ownership of the property. Okay, now this brings us to a divided interest or tenancies in common. Here, each owner has a specific share of the property. So you can sell, mortgage, or transfer your share of the property independently of the others. And if an owner passes away, their share goes to their heirs through their will and not automatically to the other owners. So tenants in common have the property in common, but each owns their respective share or percentage of the property, and that person can sell his or her portion of ownership independently from the other owner or owners. One common example of a divided ownership interest is with a condominium, where each owner owns their particular unit, and their ownership in common areas such as pools and gyms is shared according to a predetermined percentage. Now, whether your interest is undivided or divided, you might find yourself in a situation where you want to separate your share from the other owners. This is where a partition action comes into play, allowing you to divide your property or sell it and split the proceeds. So parties with an interest in the same property have what is called a right to partition in most states. So you have the complete right to have your interest separated from that of the other owners in most states. So there you have it, the complete world of undivided or divided interest in real estate simplified. So whether you're looking at buying or selling property with family or friends, understanding these concepts empower you to make informed decisions and navigate the potential legality smoothly. So thank you for tuning in. I hope you found this video useful. So give it a thumbs up and remember to subscribe for more demystified and cool real estate and asset protection concepts. So if you have questions or you have topics you'd like us to discuss in a future video, make sure to leave that in the comments below. So until next time, stay savvy, stay informed, and let's make some smart business decisions. See you next time. This is The Business Guy.